financial crisis recovery.
Foreclosure, short sales, bankruptcy, credit card debt, job loss, depreciating home values, money management. Peace of mind when it comes to your finances seems completely out of reach under current conditions, but there is a way to achieve it. For the next 60 minutes, you're going to find out how to cover your assets. Cover your assets. Now, here's nationally renowned speaker and expert on getting you on the path to financial strength, Todd Rooker.
Good morning, Twin Cities. You are listening to Cover Your Assets. As always, we'd like to encourage listeners to call in anytime with your questions. That number is 651-646-8255. If you are considering bankruptcy or know of anyone who is, or are currently going through a bankruptcy, or maybe just worried about at some point having to deal with something related to bankruptcy, I have David Kingsbury, one of the premier bankruptcy attorneys in our state. He exclusively practices bankruptcy, and David is what I would consider to be an absolute A player as it relates to bankruptcy, and this is an opportunity to be able to get some of those questions answered prior to actually being in the position of needing to file bankruptcy, or at least having enough information to know whether or not you should be considering it. So good morning, David.
Good morning, Todd. Thanks for having me back again. It's good to see you.
We are so excited to have you in here. My business, as some of you know, is all about dealing with people who are in financial crisis, and it is, do we just let the house go into foreclosure? Do we need to consider short sale, deed in lieu, loan modification, credit counseling, bankruptcy? And I have to essentially know all of those pieces and then be aligned with the best professionals that exist. So when a client needs to go to one of those people, I'm able to disseminate through their particular situation and then send them on to somebody who's really efficient and effective in that particular area. And so, as I always like to say, I don't get my referrals from the bulletin board at the coffee shop. I know who the best people are in the state, and those are the people I work with. And part of the service that I offer to my clients is to send them to people who are incredibly good at what they do, not just kind of so-so. David certainly fits that model. So let's begin here today. For the most part, consumer bankruptcies are Chapter 7 and Chapter 13 bankruptcies. There are a few rare instances where someone might do another form of bankruptcy as a personal bankruptcy. For the most part, we're looking at Chapter 7 and Chapter 13s. David, would you quickly describe what is the difference between a Chapter 7 and Chapter 13 personal consumer bankruptcy?
Well, one's a repayment plan and one's not, from a real broad view. Most people will file Chapter 7 cases by and large. There are a few instances when a Chapter 13 makes sense. Chapter 7, you can wipe out unsecured debt where there's no collateral. That'll be things like medical bills, credit cards, unsecured lines of credits, those types of things. Chapter 13 has got utility in circumstances in regard to the type of debt we're talking about. If we're looking at non-dischargeable debt in a Chapter 7 case, recent taxes, student loans, debts incurred in a divorce that you're ordered to pay, defaults on mortgages, those types of things. And so we're always going to look at doing the Chapter 7 if we can. There's a lot of different reasons why we'd look at the Chapter 13 as an alternative option. It's got utility in a number of different circumstances. And if during the case analysis that we make, if there's one or a number of those variables in a person's dynamic that makes sense for us to look at a Chapter 13, then we'll start going down that track a little bit. But usually we're looking at the Chapter 7 case.
So we're trying to, and so to be clear, a Chapter 7 is where you discharge your financial obligation to repay the debt. A Chapter 13 is a repayment plan, and oftentimes it's because you have debt that is non-dischargeable, or you've got an income that won't allow you to qualify for a Chapter 7, or maybe assets as well. Is that?
Those are a couple of the other factors. Your income's too high. You've got non-exempt assets that the trustee in a Chapter 7 case would take and liquidate so they could pay a dividend off to your creditors. In a Chapter 13, you'd keep all those assets. It can get a little bit complicated. A Chapter 13, you can say it's a repayment plan, and that's a simple way to put it. It can get fairly complicated in terms of how we have to put it together. In a perfect world, we'd just say, this is what I net, these are what my reasonable necessary living expenses are, and therefore that's what my payment is, but it never almost ever works out that way. We have to, I call it reverse engineer it. What does this thing got to do? What do we got to pay in order to meet statutory muster with what the Chapter 13 statutes require that a Chapter 13 plan pays. What does the case law say for how those statutes have been interpreted by the courts? And specifically here, it's federal law, but we're in Minnesota, so we've got to follow those decisions there too. So we reverse engineer it quite often. I say we sit down once I get through with about a 2.5 hour case analysis. Okay, these are the issues in this case. This is the target I've got to hit for the amount that the unsecured creditors are going to have to get paid after all the administrative fees are paid, the priority debts are paid, the secured claims are paid. I've got to hit that number. And we can go up to a maximum 60 months in a Chapter 13, minimum of 36. People under the median income, and I don't want to get too far down this road, but if you can do a 36-month plan, great. If not, if you're over the median, you have to go 60. Sometimes we'll take advantage of the full 60 months if we need to, because we're trying to hit that target number. And the way I describe it is kind of a visual, which is maybe a little tough to do on the radio, but let's say, you're looking at some water in a tank, and you've got so much there, and the tank's so wide. If you try and get so much into a smaller tank, you push the sides of the tank together, what's going to happen? It's going to go up. Same thing with the kind of debt you got to pay in a Chapter 13 case. If you're trying to squeeze more into less time, guess what? That payment's going to go up. So again, sometimes we'll take advantage of that whole 60 months. But the goal is, what do I got to make it pay? How much is it going to take to make it work? And can I get my budget past the trustee and approved? And they're really the ones, the judge, if the trustee doesn't have a problem with what you presented and doesn't object to your plan, the judge is pretty much going to sign off on it. But confirmation of the Chapter 13 plan is what we're looking for. And hitting that target of what we got to make it do, everybody's plan is individually tailored to their own circumstances.
That what we got to make it do is really relating to a monthly payment plan, and so you're putting forth based on what you feel are acceptable expenses within a budget, and assuming that none of those expenses are deemed to be excessive, you're putting forth a number, and of course then you've got a trustee who can bring an argument and say that that's not reasonable, or you feel it is, and therein lies where they wind up with a payment plan that is or isn't acceptable, right?
That's correct. The trustee is the trustee's attorney are the people you really have to placate here.
And the trustee is not your friend. If you're filing bankruptcy, your attorney has got a sworn enemy, and that is a trustee. While on the one hand, you got to work with him.
Well, now, Todd, I get along with all our. We've got one Chapter 13 trustee that does the metro area and a large chunk of the state, and there's an outstate one as well for everything else. And most of mine is the metro area here. They're people just like you and me, and they've got kids and families and everything else, and they've got a checkbook and a budget too, so they can relate. But they have a job. The staff attorneys, they're very diligent. Their job is really to protect the process and the creditors as a whole. The whole idea is that if you're looking at doing a repayment in Chapter 13, you in good faith have to pay into the plan the disposable income that you have available that you get during that pendency of the plan term, whatever that is, which can be wages. And again, the analysis is, what do I make? What's my net? What's my reasonable necessary living expenses? And that's what I pay in there. And of course, again, we tweak it a little bit. The budget has got a little bit of fluff in it. There are certain aspects of it that are fixed numbers, the sum certains I call them. We're not going to play around with mortgage amounts or car payments or something like that, because we know what those are every month. But recreation and food and clothing, if I've got a plan where I've got to find money, I'm going to go really light on those kinds of expenses because I just got to have that money for the trustee to do what my client needs that plan to do. On the other hand, if I've got a plan where I've got what I call a lot of slop at the end of it, I'm going to take advantage of what is reasonable on the other end of the top side of the budget. And you can call it puffing a little bit, but the idea or the sense that I give people is you want to be reasonable in terms of your budget. You can't go crazy.
So what we're really talking about here is we're talking about the difference between a payment plan, which is primarily what we're discussing here, versus being able to discharge your debt and be done. So how does a person qualify? Because obviously if a person is determined that they are going to file bankruptcy, most of them are of the belief that they're going to be in a Chapter 7 and be able to discharge their debt and move on with their lives. While they may have believed that they'd never be here, now that they are, they sure don't want to be in a 5-year payment plan if they can help it. So how do you, what are the determining factors that discern whether you can or cannot qualify for a Chapter 7 as opposed to winding up having to do a 13? What are those issues? The income, the assets, what are they?
Lots, but if you break it down to a real simple 4-prong test, the analysis is income-based. 2 of them are income. Past income. The new bankruptcy legislation in 2005 came up with a wonderful thing called the means test. It's historical. What'd you make in the last 6 months? Divide it by 6. Take it by 12 to annualize the income. Where do you fall according to your household size? Are you below or above the median income? The presumption is that you're above the median income, you're going to be doing a Chapter 13 case. Not always, because sometimes you can do what's called rebut the presumption if you can take certain allowable deductions off of the income to get you under the presumption amount. The second income test is the old way of doing this that I've been doing over 22 years or so that I've been doing bankruptcy cases. It hasn't been replaced by the means test. It's just been supplemented by it. That was called, it's called the totality of the circumstances. And that's, again, what do I make? What's my net? What are my reasonable necessary living expenses? Short version of the formula is if you're upside down at the end of the month, and a lot of people are, that's the end of the math. Then we don't have to worry about it. If you have some money left over, that's the disposable income. Then we take a look at what does this person have for unsecured debt? And based on a case that's fairly old in this circuit, if you can pay back roughly in the low 20 percentile of your unsecured debt in 36 months, the United States Trustee's Office is going to bring a motion to dismiss your Chapter 7 case because they figure you can make a reasonable repayment. So the other analysis, assets, what do you got? Can I protect it all? Because if you got some non-exempt assets, you may want to do a Chapter 13. And the last one, and this is kind of a sleeper for a lot of folks, transfers. Have you sold things? Have you given things away? Have you paid back your friends or relatives? A lot of people do that around tax time. Have you preferred one creditor over another? The trustee in your bankruptcy case will go back to those creditors, get the money. It's called, popular term for it, clawback. You heard that in the Denny Hecker case, right? To drop a name, their big bankruptcy case. Trustee there did clawbacks, got a lot of money back for the creditors. And, that's okay if it's a credit card company or in Hecker's case, maybe a country club or something like that. But if it's your mom or your dad or your brother that you paid back, that's going to hurt a little bit. So you may want to consider doing a Chapter 13 so we don't have those kinds of issues, So those are income, assets, transfers. Those are the big ones.
Those are the big ones. So with a client or consumer who comes in, you're really looking at whether or not they meet the means test. And let's say we've got